Good evening. My name is Kevin Perry, and I am a third-year law student here at the University of Richmond. And my project dealt with issues of education records and their use in legal representation. My goal was to try to create something, a digital manual that in some ways could compel attorneys working in criminal defense to use these records in defending their clients. As I moved forward with this in support of this goal, I had a couple of thoughts as to how this effort could be achieved. And so my initial goal was to create this manual that would assist in pretrial, trial, and all types of negotiation that would happen between the defense attorney and prosecution. I would have sample forms. I would have guidance documents that could indicate to the attorneys how to use these records, where to look inside the records. And as I was preparing for this presentation, I thought there's a couple of ways we could go about this. One way was that I could simply list all the various documents that I had, and I could link to them. And then what we could do is I could pull them up one by one, and we could go through each one of these line by line, and you would be very interested in that. But as I thought about that, and I thought about the information that was contained, and I thought about this statute here that I was pointed to by Professor Volnick. And this statute's really very interesting, and it would be more compelling by the end of my presentation than it is right now. But just to give you a brief understanding of it, it's a simple statute that's been out there on the books here in Virginia for several years. In early 2000, it was enacted. And what it essentially says is that a court-appointed attorney can, at any time, with a juvenile client, go access an education record and a health record. And they can also get some help with that and get a mental health professional to come and assist them in understanding how to get through this record and how to use it in their client's representation. But as your eyes are glazing over right now, I can only imagine how much worse it would be if I actually pulled up all these documents. And so instead, I decided I would go in a different direction. And what I would do is really get to the core of why you guys are all here. What's the value in this project? Why should this project be supported? And to do that, I thought I would go through two specific prongs. One, we would talk about the pessimism that I had halfway through this internship. Why I thought that the practical nature of what I was trying to get accomplished was really somewhat useless. And the second issue that I really would have wanted to focus on was the gravity of some of the decisions that people in the criminal justice system have to make. The clients, the defenders, even the prosecutors. Back to my pessimism. This summer I worked in the public defender's office in Fredericksburg, Virginia. It's a great office. They support not just the city of Fredericksburg, but 3 of the surrounding counties, Stafford, Spotsylvania, and King George. These people are wonderful. They're intelligent. They're hardworking. They have a huge number of cases. As a litigator to be, this is a perfect place for me. I could find myself in court one day representing up to 30 clients. But that also tells you how limited their time is. Because that afternoon, they've got to go back to the office, and they've got to study and research and do the work for the next day's clients, which could be another 30 clients. And so that's the core of my pessimism. That's where it all sort of generated from. Because as I broached what my project was about, as I tried to touch base with some of the other defenders in the office and say, gosh, look at this, we could use this sort of information, it's really, really important, they would look at me like I was crazy. Why would they want to wade through an education record even if it did have some sort of usefulness? Well, what is an education record? You can say, well, it's a few grades, right? And you'd be mistaken, actually. And so what I did is I took the liberty of bringing an education record. And this here is the first 2.5 years of my son's education record in Spotsylvania County. He's now 7. He's been in the system for 5 years. So somewhere in some school, there's another bin just like this. And it's got all kinds of great information. It's got education plans. He's got some disabilities, so he's in the special education program. And so it's also got evaluations. There's psychological recommendations. There's data sheets. There's behavioral issues that are in there. All sort of great documents. And there's some grades, too. This is the type of thing that a public defender would look at me and say, "Are you crazy? Why would I want to get into that?" So I was somewhat pessimistic halfway through this internship, thinking to myself, I'm a salmon swimming upstream here. There's no way I can convince somebody, even if I can tell them exactly where to go to, what they should pull out and how they could use it and how I could make it so simple for them so that they would say that this is something that I can use in representing my client. So I had a conversation with Cassie about halfway through, and I said, "Look, I'm a little dejected at this. I'm not sure this is working out the way that I anticipated. The practical nature of this seems to be pretty limited." And she said, "Okay, well, that's fine." She was actually really good about it. She said, "Sometimes we get into this and it doesn't turn out to be what we want, and that's okay." And about a week later, I got a gift, and this gift was actually in the form of a trial that was happening in Stafford County. And that brings me to the second point. Before I get into the details of that trial, I'd like you to understand the gravity of some of the decisions that people have to make when they interact with the criminal justice system. And so if you would, indulge me for a moment, and imagine, if you would, that you're the parent of a 15-year-old. And he's a 15-year-old boy, and he's a great kid. He's affable, he's a little gullible, he's sweet. Everybody likes him. But he's got some issues. In every way, he seems typical, but when it comes to school, it's really not his forte. In fact, some people would say he's borderline intellectually disabled. So he gets services at school. He gets some tutoring, maybe he gets some social help. When it comes to exams, when it comes to tests, he gets some accommodations. And that's your kid, and he's great. Well, one evening you come home, and your son meets you at the door, and you're like, "Hey, how are you?" And he says, "Dad, I'm doing great. Had a great afternoon. I went to a friend's house. It was fun." You're like, "Yeah, did you do your homework?" He says, "Yes," because every child has done their homework before their parents come home. And so you busy yourself about the business of that evening. And maybe you go in the house, you fix dinner, you watch TV, you pull out the newspaper, and you settle into the evening. And maybe a few minutes later, there's a knock at the door, and you go to answer the door, and there's a police officer. And you say, "Hi, officer, what's going on? How can I help you?" And the officer says, "Well, is your son home?" And you look behind you, and your son's standing right there, and he's like, "Dad, what's up? What's going on?" "I don't know." And you ask the policeman, "What's going on?" "Officer, yes, it's my son. He's here." And the officer presents you with a warrant for his arrest. And he comes in, he grabs your son, and takes him out. And you don't know what's going on. Your son's crying. And you don't know what's going on. You're in shock. And the officer proceeds to take your son out and put him in the car. And you find out that he's being charged with aggravated rape of a 14-year-old. Your son, you never thought would be in any trouble. He's never been in any trouble. He's a good kid. And all of a sudden, you're facing something that's your worst dream. And your son is taken, he's put in the car, and he's taken to the detention center where he's going to stay for quite some time. In the meantime, before his next court appearance, you get a court-appointed attorney. And this attorney, she seems sweet, she seems nice, she seems to have some of these interests in mind to help your kid. And you explain some of the problems. You're like, "Hey, my kid's good. He never would have done this, ever." And he says, "I never did this." And she says, "Oh, okay, well, I'll take that into consideration." And then she begins to explain to you the gravity of the situation. The prosecuting attorney wants to transfer your son from juvenile court into adult court. If your son is convicted in adult court, she explains to you, he could be put in prison for the rest of his life. And that's your 15-year-old. You're scared. The transfer hearing is coming up, and you go to court at that appointed day, and you walk in, and you have to wait. You've already been told it's going to take a while. And right before his case is to be called, your court-appointed attorney comes to you, and she says, "Come here, I finally got a plea deal from the prosecutor." And you're like, "Okay, is it good? Is it bad?" She goes, "Well, it's good. Let's just go talk." And so she takes you to a back room, you sit down. Your son is there. And she says, "Well, this is what he's offered. If you take the plea, your son won't get transferred into adult court." You're relieved. But then she says, there's also some bad with it. He's going to have to do some active incarceration, and he's going to have to be on the sex offender registry for the rest and that's your 15-year-old. This type of decision is pretty serious. And it was the decision that the Cokers had to face back in 2007. They, of course, took the plea at the risk of having their son put in jail for the rest of his life. And so what was the negative of that? You could say, well, if you've ever been online and looked at the sex offender registry and you tried to see if you had any sex offenders in your neighborhood, lurking in some dark corner, you'd probably find some. And Edgar is still on the sex offender registry. And so in 2011, he's arrested. He's arrested at the high school that he just graduated from, returning for a football game. And he's arrested because he's around minors, and the sex offender can't be around minors. So the culprit police take him in. Fortunately, at that point, the Innocence Project at UVA had gotten involved. And why had the Innocence Project at UVA gotten involved? And why do we even know about this case? Because 9 times out of 10, we would never have found out about it. But 2 months after the plea deal was entered, or several months after it was entered, the girl recanted the story. She called her mom in. She said, "Mom, I'm sorry. I lied about this whole thing. I had invited him over. I had actually convinced him to do what he did. No, I'm sorry." And to her credit, the mother, the entire time, since that moment, has tried her hardest to get Edgar cleared of what she thinks and is a charge that they never did. And so, why would I bring this up and bring up these education issues? Well, back to the case that occurred a week after I spoke to Cassie. In order to, because of a bunch of procedural issues in Virginia law, you can't just clear someone's record after it's been implemented in very simply. And so there's this whole process. And part of this process that the Edgar Coker family was trying to use is the ineffective assistance of counsel. They had to prove that the court-appointed attorney didn't do her job. And how would they prove that? Well, what they did and what they had gone through is they'd gone through trying to illuminate the fact that this education record should have been used. That they should have been able to point out that the child was intellectually disabled. Because the child was intellectually disabled, he first of all may not even have understood what the plea deal was about, what he was entering into. They brought in a professional attorney from up north, William Reichart, who's known in attorney fields as an expert in some of this type of litigation with children. And he testified and he said, she should have used the education record. Why? Because not only would it have demonstrated that your client couldn't have easily done what you thought, but there were also other issues with the young lady. And if the attorney had done any efforts at all at investigating the record and investigating the school, she had found out that the witnesses the prosecution was going to bring in to confront Edgar would have actually supported her client instead. So my goal is to make no more Edgar Cokers appear. In this effort, our hope is to make it simple enough for attorneys to look at these documents, to wade through them, and find exactly what they need quickly and efficiently. It's something that should be done anyway right now. But there's a real reticence because of the culture and because of the need to produce. In closing, we're going to take the digital manual that has been created, and we're going to refine it a bit. We're going to maybe add some more documentation to it. We're going to present it at the Juvenile Law and Education Conference that happens here at the University of Richmond in May. And this is why this effort was worth supporting. In closing, I'd like to also thank you for the support and the encouragement that has been given through this program on behalf of Professor Volanik and Alan Bereford, who was my supervisor, the public defender in the field. Thank you.